Hi, I'm Shan Wu with a undercolor of law analysis of the U.S. Attorney for D.C., I guess he's still the acting one, Ed Martin, now accusing members of the U.S. Congress of threatening public officials and opening a criminal investigation into them. Now, this is our friend Ed Martin, just our friend in quotes there, and he's now been nominated to become the permanent United States Attorney for D.C., my old office. Reminder, largest U.S. Attorney's Office in the country. They handle all the local crime, street crime, as well as traditional federal ones. They took the brunt of the January 6th prosecutions. Practically all of those came out of that office. So the line prosecutors there did one heck of a job with those hundreds of cases. So Ed Martin, who has no background in D.C. really, hasn't been a prosecutor, hasn't been a judge. He has been a criminal defense attorney. I was correcting a colleague of mine on CNN the other day who said that Martin had no criminal experience, meaning he hadn't even been a defense attorney, but he has. He was a defense attorney for one of the January 6th defendants, so he then got to dismiss the case against his own client. Ridiculous conflict of interest. You might ask why the DOJ Office of Professional Responsibility, OPR, isn't looking at that, but more on that later. So Ed Martin has made a habit of making announcements, sometimes sort of like kissing up to Elon Musk, and he likes to scan these letters to Musk and put them on X, claiming that they're only being shared on X. He wants to treat X, Twitter, as his official government communications platform, probably also to curry favor and make Elon Musk happy. And we put up the headline here about what it is that Ed Martin is now doing. And he wants to look at statements by Schumer and also by Garcia that he thinks are warranted for criminal investigations into whether they pose a threat. And he also says in a second letter to Musk, Martin says that he's going to go after, quote, even those who acted simply unethically, and that he will, quote, chase them to the ends of the earth to hold them accountable. And then adds, of course, none is above the law. Side note trivia point, I'll put up my post for fun. I'm not sure who Noon is, although there is a Peter Noon, very well-known 60s pioneering rock and roll artist who I guess Martin feels should be above the law. I digress. Now, take a look at some of the reporting about his idea, Martin's idea, that this deserves a criminal investigation. You can take a look at the text of his letters here, and something that Martin seems to be forgetting is how odd and unusual and unheard of it is to investigate members of Congress for supposed threats. Now, there's a whole bunch of safeguards here and hoops that would have to be jumped through, of which he's doing none of them. So first of all, having worked at a very high level in justice, being counsel to the Attorney General, I can tell you that there's a whole bunch of layers that come up whenever members of Congress are involved. Part of the reason for that isn't simple deference to those folks and being afraid of pissing off a member of Congress, but also it comes out of respect for the separation of powers. That's the legislative branch. This is the executive branch. And traditionally, the executive branch in the form of DOJ wants to be very careful about appearing as though they are trying to influence the legislative branch. Common example, a member of Congress writes DOJ and says, my constituents have brought to me their concerns about this particular plant being built in their town. And I want to make sure that the department's aware of their concerns. Take a look at this. And the letter will usually stop short of making what's called a referral, meaning you must open this investigation. But sometimes it's saying we're making a formal referral to DOJ. DOJ is very careful about those kinds of referrals because they want to make sure it doesn't seem as though the legislature is dictating to them what to look at and what not to look at. And they also don't want to act as though, well, if a congressperson writes, we're going to do absolutely everything that they say. Having said that, those letters are sometimes looked at with a little bit of a grain of salt, meaning we have to pay attention to it because it's coming from a member of Congress. But on the other hand, the congressperson may be just acting in a political way of grandstanding. before they'd ever open a criminal investigation into a member of Congress, it would have to go through a very careful vetting because they don't want egg on their face and they want to make sure it's not seen as, oh, we're politically punishing a member of Congress for some viewpoint that they've expressed. Improper. Get to the second bit of protection and an issue for Mr. Martin. There's something in the Constitution called the Speech and Debate Clause. We'll put that up for you. And that's basically summarized as saying you don't get to prosecute or arrest members of Congress for something that they're saying during a legislative debate. That's something else that normally DOJ's Office of Legal Counsel, that's the sort of smart legal section that just looks at kind of theoretical issues. We used to call them the egghead section. They would look at this very obviously and ask, okay, what are you doing here? Is this protected under speech and debate? So let's take a medium depth dive into that. In essence, what's said in Congress versus what's said without. What's said within Congress gets protected by speech and debate. So if you look at the two instances that Martin is targeting here, Representative Garcia and Chuck Schumer's statement, you'll see that slight distinction in facts, right? Schumer had made a remark years ago at an outside rally. Arguably, that's not within speech and debate. But the very next day, he said he shouldn't have made those remarks. He considered them to be intemperate, wanted to make sure nobody interpreted it as a call for any harassment or violence. He was criticizing Supreme Court justices. So right off the bat, not only does it seem kind of ridiculous that his statement was really intended as a threat or harassment, that really should have been the end of any inquiry into whether they should open up an investigation. But also, right off the bat, you have this legal complication. The very next day, he mentioned it within Congress, albeit saying intemperate, shouldn't have said that, which kind of lands it right back in the speech and debate clause protection issue. So that's something to have to keep in mind. The other instance where Representative Garcia is in a hearing with Marjorie Taylor Greene, who is showing pictures of Hunter Biden's genitalia, and she refers to it as a, quote, DI asterisk pic. Like, first of all, just obviously, how in the world, going back to that history, was that relevant to anything about Biden, corruption, national security? Obviously, it wasn't. I mean, she just wanted to, like, embarrass Hunter Biden. Well, in response, Garcia referred to Elon Musk as being a similar portion of the male genitalia. And based on this, which was in Congress in a subcommittee hearing, Ed Martin wants to open an investigation into that because he wants to make sure that no one is putting down Elon Musk. That is not any kind of threat or harassment. That's clearly within the space of Congress, albeit a really kind of dumb debate, but it's a legislative function. They're in Congress in a committee hearing. So another reason why that one should not even get any serious consideration at all. Then we can talk about what you'll see a lot in the press about First Amendment considerations. What, no one is now allowed to criticize Elon Musk because that is an improper thing to do. No one has a First Amendment right to talk about that anymore, including members of Congress. So that by itself is just a ridiculous type of argument. But you're going to see a lot of talk about that, posturing this or posing it as a First Amendment issue, which it is. But, you know, I really don't think that's the most important issue. Sure, it's a First Amendment issue. Sure, Martin is trying to use the government to censor people's remarks or opinions about public figures he wants to curry favor with, his political bosses. And sure, that is a textbook example of censorship and an abuse of the First Amendment. That's exactly what the government shouldn't do, is using the enormous threat and power of criminal prosecution, criminal investigations to punish people's speech, right? Classic First Amendment issue. But at a more practical level, you got to ask this as a former alum of DOJ. And once you learn that there's something called the Office of Professional Responsibility, OPR. They oversee the ethics and the behavior of prosecutors who work at DOJ. If something comes up in a trial where a motion for prosecutorial misconduct has been filed, if a judge questions what a prosecutor has done, if a citizen writes in and talks about it, That goes to OPR to consider, do we need to do an investigation? Do we need to look at the behavior of our employees, the prosecutors? Why should OPR be looking at Ed Martin's actions here? He is opening a criminal investigation without, in my opinion, any proper predicate. Okay, standard caveat, me and you were looking at this from the outside, right? I mean, maybe he has some other information that is secret that really presents more of a concern about a threat that Senator Schumer or Representative Garcia poses to these public figures. I kind of don't think so, because knowing Martin's style, he would already put that out on Twitter, but okay, give him the benefit of that doubt, kind of. It doesn't appear, though, to be any proper predicate. You need something to open the investigation. It can't be you just feel like opening the investigation, or you just want to open one to kind of slime up somebody. That's what OPR should be keeping an eye on here, so that if they're still functioning, that's something that he should be subjected to scrutiny over, not Garcia and Schumer. Now, reminder, the head of the D.C. U.S. Attorney's Office Criminal Division resigned over something similar here. Remind us, this was just last week, but so much happens. She had been asked to open up a criminal investigation, grand jury subpoena, and try to freeze a bank account over a policy decision that the Trump administration didn't like. And she was ordered to do that by Martin, and she refused, because it goes contrary to her prosecutorial ethics, goes contrary to the U.S. Attorney's manual when you can open a case. Remember, grand jury is to determine, is there probable cause of a crime? You need that, and you also need some quantum of evidence to begin looking at that question. And there doesn't appear to be anything like that here. That's it for now. Need to keep an eye on this, all of us do, because there are going to be tons and tons of similar actions being taken, not only by Ed Martin in D.C., but by Maine justice, because they have signaled loud and clear, and they're beginning to do these actions where they want to use the criminal justice system to punish enemies, political enemies that don't agree with them. So we're going to keep an eye on that. That's it for now. Thanks for listening. Keep those replies and comments coming. Really great to see them, and gives lots of ideas for us to take some medium and deeper dives on different topics. Talk to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.